we'll just wrap it all up with some key points, and we'll do it in the order of presentation. So, Matt, I would like to start with you, Matt Germane. Do you have some key takeaways for the audience?
Sure. Yeah, thank you. So 3 points just to remind you of that when measuring lost profits, if we're dealing with a situation like COVID that has a significant impact on an industry or on the economy, the two-model approach to calculating lost profits may facilitate that calculation and allow you or provide you a method to think through the impacts of the bad act, why we're in the lawsuit, separately from COVID. The second point is when you're measuring lost revenues, and I touched upon this a little bit in the question and answer period, that the yardstick method is designed to account for many intervening factors, and so it may be an appropriate method to use in a calculation that's affected by COVID-19. And then finally, know your industry. Research, study the industry in which the company operates. Every industry has been impacted differently by COVID-19, and understanding how COVID-19 has affected an industry is critical to being able to reasonably project a business's revenue. And I think following those will help damage experts keep their calculations, quote unquote, reasonably certain within the context of the court and what's required there.
Thank you for that, Matt. Zachery, Baldwin, a minute for some key takeaways.
Yeah, absolutely. Thank you. And I'd like to thank whoever sent me the question of, is there a one-size-fits-all question? That perfectly was the softball question for giving my recap, but just a recap of the recap. There isn't a one-size-fits-all method when calculating incremental costs, as much as we would like there to be an automated process to calculate incremental costs. It really does take thinking about it, doing some analysis, doing some interviews with management, looking at the P&L, seeing how costs have changed with the accused lost revenues, and coming up with a sound conclusion that will stand up with the courts. And as Eric pointed out, we might not, the experts might not agree on what the inputs are, but as long as the methodology is sound, I think you're safe from any sort of Dalbert motion or any exclusionary motion to get you excluded.
Thank you, Zachery, Baldwin. Will Boesen, a minute for you. Key takeaways.
Yeah, first would just be to really understand what's at stake with ex ante versus ex post damage calculations. You can't always be certain how the court will rule on those, but you can be a real asset to the attorney you're working with if you're a damage expert to kind of know what's at stake and have those concepts in mind when you're doing your damage calculation, especially in the era of COVID-19, where the differences can be so stark between those two damage methods. Secondly, I'd like to reiterate that when performing a fair market valuation of a company at a specific date, the law or the rules for damage experts really do say you can only use information known or knowable at the valuation date, but that doesn't mean you can't look past your damage date to see if some of those things in the future were knowable at the valuation date. And finally, just to drive home the point, when you account for intervening factors, do it as explicitly as possible and really outline those intervening factors you've considered in your report, even if it's just saying that I use the yardstick approach, which does a great job of accounting for a lot of intervening factors. List it out and list out those factors. It will really help support your report and defend it from other experts.
Thank you for that, Will. And finally, Eric Macey, your key takeaways.
Yeah, this is what I would say. First, there's going to be an enormous, a very, very large number of cases because of COVID-19 that are, because of its impact on businesses, that will generate a large number of cases that will require lost profits calculations. That's the first. The second thing is that the timeline for civil cases involving lost profits to get to court is going to stretch out materially and continue to stretch out materially, I believe at least 6 months in your case. Lastly, as I mentioned, despite the impact of COVID on cases generally, or how you calculate your lost profits, okay, what still matters is that you use a methodology that is acceptable under the judicial standards outlined, and that's it. Thank you.